a WikiVidi documentaries production. Don't forget to like and subscribe. Enjoy. Neil Gorsuch. Neil McGill Gorsuch is an Associate Justice of the Supreme Court of the United States. He was nominated by President Donald Trump to succeed Antonin Scalia and took the oath of office on April 10, 2017. Gorsuch is a proponent of textualism in statutory interpretation and originalism in interpreting the U.S. Constitution. Along with Justice Clarence Thomas, he is an advocate of natural law jurisprudence. Gorsuch clerked for Judge David B. Sentelle of the U.S. Court of Appeals for the D.C. Circuit from 1991 to 1992, and then for U.S. Supreme Court Justices Byron White and Anthony Kennedy, from 1993 to 1994. He is the first Supreme Court justice to serve alongside another justice for whom he once had clerked. From 1995 to 2005, Gorsuch was in private practice with the law firm of Kellogg, Huber, Hansen, Todd, Evans and Figel. Gorsuch was Principal Deputy Associate Attorney General at the U.S. Department of Justice from 2005 to his appointment to the 10th Circuit. Gorsuch was nominated to the United States Court of Appeals for the 10th Circuit by President George W. Bush on May 10, 2006, to replace Judge David M. Ebel, who took senior status in 2006. He holds a Bachelor of Arts from Columbia University, Juris Doctor from Harvard University, and Doctor of Philosophy in Law from the University of Oxford, where he took courses and defended a doctoral thesis concerning the morality of assisted suicide, under the supervision of philosopher John Finnis. Early life and education. Gorsuch is the son of David Ronald Gorsuch and Ann Gorsuch Burford, a Colorado House of Representatives member who was later appointed by President Ronald Reagan to be the first female administrator of United States Environmental Protection Agency in 1981. A fourth-generation Coloradan. Gorsuch was born in Denver, Colorado, and attended Christ the King, aka Catholic School. In 1985, he graduated from Georgetown Preparatory School, a Jesuit school in North Bethesda, Maryland. While attending Georgetown Prep, Gorsuch served as a United States Senate page in the early 1980s. He received his Bachelor of Arts degree in Political Science from Columbia University in 1988, where he was inducted into Phi Beta Kappa. He was also a member of Phi Gamma Delta fraternity. As an undergraduate student, he wrote for the Columbia Daily Spectator student newspaper. In 1986, he co-founded the alternative Columbia student newspaper The Fed. Gorsuch attended Harvard Law School where he graduated cum laude in 1991 with a Juris Doctor. He received a Harry S. Truman Scholarship to attend. While at Harvard, Gorsuch was an editor on the Harvard Journal of Law and Public Policy. He was described as a committed conservative who supported the Gulf War and congressional term limits. On a campus full of ardent liberals, former President Barack Obama was one of Gorsuch's classmates at Harvard Law. In 2004 he was awarded a D.Phil in Law from the University of Oxford, where he completed research on assisted suicide and euthanasia as a postgraduate student of University College, Oxford. A Marshall Scholarship enabled him to study at Oxford where he was supervised by the natural law philosopher John Finnis. In 1996, Gorsuch married his wife Louise, an English woman, and champion equestrienne on Oxford's riding team whom he met during his stay at Oxford. Clerkships. Gorsuch served as a judicial clerk for Judge David B. Sentelle of the United States Court of Appeals for the D.C. Circuit from 1991 to 1992, and then for Supreme Court of the United States Justices Byron White and Anthony Kennedy from 1993 to 1994. Gorsuch's work with White occurred right after White retired from the Supreme Court. Therefore, Gorsuch assisted White with his work on the 10th Circuit, where White sat by designation. Gorsuch was part of a group of 5 law clerks assigned that year, which included Brett Kavanaugh, who described Gorsuch at the time stating, "He fit into the place very easily." He's just an easy guy to get along with. He doesn't have sharp elbows. We had a wide range of views, but we all really got along well. Private law practice. Instead of joining an established law firm, Gorsuch decided to join the 2-year-old boutique firm Kellogg, Huber, Hansen, Todd, Evans, and Figel, where he focused on trial work. After winning his first trial as lead attorney, a jury member told Gorsuch he was like Perry Mason. He was an associate in the Washington, D.C. law firm from 1995 to 1997 and a partner from 1998 to 2005. Gorsuch's clients included Colorado billionaire Philip Anschutz. At Kellogg Huber, Gorsuch focused on commercial matters, including contracts, antitrust, RICO, and securities fraud. In 2002, Gorsuch penned an op-ed criticizing the Senate for delaying the nominations of Merrick Garland and John Roberts to the United States Court of Appeals for the District of Columbia Circuit, writing that the most impressive judicial nominees are grossly mistreated by the Senate. In 2005, at Kellogg Huber, Gorsuch wrote a brief denouncing class action lawsuits by shareholders. In the case of Dura Pharmaceuticals Incorporated v. Brudo, Gorsuch opined that the free ride to fast riches enjoyed by securities class action attorneys in recent years appeared to hit a speed bump, and that the problem is that securities fraud litigation imposes an enormous toll on the economy, affecting virtually every public corporation in America at one time or another, and costing businesses billions of dollars in settlements every year. U.S. Department of Justice. Gorsuch served as principal deputy to the Associate Attorney General, Robert McCallum, at the United States Department of Justice from 2005 until 2006. As McCallum's principal deputy, Gorsuch assisted in managing the Department of Justice's civil litigation components, which included antitrust, civil rights, environment, and tax divisions. While managing the United States Department of Justice Civil Division, Gorsuch was tasked with all the terror litigation arising from the President's War on Terror, successfully defending the extraordinary rendition of Khalid el-Masri, fighting the disclosure of Abu Ghraib torture and prisoner abuse photographs, and, in November 2005, traveling to inspect the Guantanamo Bay detention camp. Gorsuch helped Attorney General Alberto Gonzales prepare for hearings after the public revelation of NSA warrantless surveillance, and worked with Senator Lindsey Graham in drafting the provisions in the Detainee Treatment Act which attempted to strip federal courts of jurisdiction over the detainees. Tenure as U.S. Circuit Judge. In January 2006, Philip Anschutz recommended Gorsuch's nomination to Colorado's U.S. Senator Wayne Allard and White House counsel Harriet Miers. On May 10, 2006, Gorsuch was nominated by President George W. Bush to the seat on the United States Court of Appeals for the 10th Circuit vacated by Judge David M. Ebel, who was taking senior status. Like Gorsuch, Ebel was a former clerk of Supreme Court Justice Byron R. White. The American Bar Association's Standing Committee on the Federal Judiciary unanimously rated him well qualified in 2006. Just over 2 months later, on July 20, 2006, Gorsuch was confirmed by unanimous voice vote in the U.S. Senate. Gorsuch was President Bush's fifth appointment to the 10th Circuit, when Gorsuch began his tenure at Denver's Byron White United States Courthouse. Justice Anthony Kennedy administered the oath of office. During his time on the Court of Appeals, 10 of Gorsuch's law clerks went on to become Supreme Court clerks, and he was sometimes regarded as a feeder judge. One of his former clerks, Jonathan Papik, became an Associate Justice of the Nebraska Supreme Court in 2018. During his time on the Circuit Court, since 2008, Gorsuch was a Thompson Visiting Professor at the University of Colorado Law School, teaching one course per semester, either ethics or antitrust law. Freedom of religion. Gorsuch advocates a broad definition of religious freedom that is inimical to church-state separation advocates. In Hobby Lobby Stores v. Sebelius, Gorsuch wrote a concurrence when the en-banc circuit found the Affordable Care Act's contraceptive mandate on a private business violated the Religious Freedom Restoration Act. That ruling was upheld 5-4 by the Supreme Court in Burwell v. Hobby Lobby Stores Incorporated, when a panel of the court denied similar claims under the same act in Little Sisters of the Poor Home for the Aged v. Burwell. Gorsuch joined Judges Harris Hartz, Paul Joseph Kelly Jr., Timothy Timkovich, and Jerome Holmes in their dissent to the denial of rehearing en banc. That ruling was vacated and remanded to the 10th Circuit by the per curiam Supreme Court in Zubik v. Burwell. In Pleasant Grove City v. Summum, he joined Judge Michael W. McConnell's dissent from the denial of rehearing en banc, taking the view that the government's display of a donated Ten Commandments monument in a public park did not obligate the government to display other offered monuments. Most of the dissent's view was subsequently adopted by the Supreme Court, which reversed the judgment of the 10th Circuit. Gorsuch has written that the law doesn't just apply to protect popular religious beliefs. It does perhaps its most important work in protecting unpopular religious beliefs, vindicating this nation's long-held aspiration to serve as a refuge of religious tolerance. Administrative law. Gorsuch has called for reconsideration of Chevron USA Incorporated v. Natural Resources Defense Council Incorporated, in which the Supreme Court instructed courts to grant deference to federal agencies' interpretation of ambiguous laws and regulations. In Gutierrez-Brizuela v. Lynch, Gorsuch wrote for a unanimous panel finding that court review was required before an executive agency could reject the circuit court's interpretation of an immigration law. Alone, Gorsuch added a concurring opinion criticizing Chevron deference in national cable and telecommunications as an v. Brand X Internet services as an abdication of judicial duty, writing that deference is more than a little difficult to square with the Constitution of the framers' design. In United States v. Hinckley, Gorsuch argued that one possible reading of the Sex Offender Registration and Notification Act likely violates the non-delegation doctrine. Antonin Scalia and Ruth Bader Ginsburg had held the same view in their 2012 dissent of Reynolds v. United States. Interstate commerce. Gorsuch has been an opponent of the Dormant Commerce Clause, which allows state laws to be declared unconstitutional if they too greatly burden interstate commerce. In 2011, Gorsuch joined a unanimous panel finding that the Dormant Commerce Clause did not prevent the Oklahoma Water Resources Board from blocking water exports to Texas. That ruling was affirmed by a unanimous Supreme Court in Tarrant Regional Water District v. Herman. In 2013, Gorsuch joined a unanimous panel finding that federal courts could not hear a challenge to Colorado's internet sales tax. That ruling was reversed by a unanimous Supreme Court in Direct Marketing Assen v. Broll. In 2016, the 10th Circuit panel rejected the challenger's Dormant Commerce Clause claim, with Gorsuch writing a concurrence. In Energy and Environmental Legal Institute v. Joshua Epple, Gorsuch held that Colorado's mandates for renewable energy did not violate the Commerce Clause by putting out-of-state coal companies at a disadvantage. Gorsuch wrote that the Colorado Renewable Energy Law isn't a price control statute, it doesn't link prices paid in Colorado with those paid out of state, and it does not discriminate against out-of-staters. Campaign finance. In Riddle v. Hickenlooper, Gorsuch joined a unanimous panel of the 10th Circuit in finding that it was unconstitutional for a Colorado law to set the limit on donations for write-in candidates at half the amount for major party candidates. Gorsuch added a concurrence where he noted that although the standard of review of campaign finance in the United States is unclear, the Colorado law would fail even under intermediate scrutiny. Civil rights. In Planned Parenthood v. Gary Herbert, Gorsuch wrote for the 4 dissenting judges when the 10th Circuit denied a rehearing on bank of a divided panel opinion that had ordered the Utah governor to resume the organization's funding, which Herbert had blocked in response to a video controversy. In AM on behalf of her minor child, FMV, Ann Holmes, the 10th Circuit considered a case in which a 13-year-old child was arrested for burping and laughing in gym class. The child was handcuffed and arrested based on a New Mexico statute that makes it a misdemeanor to disrupt school activities. The child's family brought a federal 42 U.S.C. Section 1983 action against school officials and the school resource officer who made the arrest, arguing that it was a false arrest that violated the child's constitutional rights. In a 94-page majority opinion, the 10th Circuit held that the defendants enjoyed qualified immunity from suit. Gorsuch wrote a 4-page dissent, arguing that the New Mexico Court of Appeals had long ago alerted law enforcement that the statute that the officer relied upon for the child's arrest does not criminalize noises or diversions that merely disturb order in a classroom. Criminal law. In 2009, Gorsuch wrote for a unanimous panel finding that a court may still order criminals to pay restitution even after it missed a statutory deadline. That ruling was affirmed 5-4 by the Supreme Court in Dolan v. United States. In United States of America v. Miguel Perez, Gorsuch ruled on a case where a felon owned a gun in a jurisdiction where gun ownership by felons is illegal. However, the felon did not know that he was a felon at the time. Gorsuch concurred with the opinion that the only statutory elements separating innocent gun possession from criminal conduct in sections 922 and 924 is a prior felony conviction, so the presumption that the government must prove mens rea here applies with full force. In 2013, Gorsuch joined a unanimous panel finding that intent does not need to be proven under a bank fraud statute. That ruling was affirmed by a Supreme Court unanimous in judgment in Lufrin v. United States. In 2015, Gorsuch wrote a dissent to the denial of rehearing on bank when the 10th Circuit found that a convicted sex offender had to register with Kansas after he moved to the Philippines. The 10th Circuit was then reversed by a unanimous Supreme Court in Nichols v. United States. Death penalty. Gorsuch favors a strict reading of the Anti-Terrorism and Effective Death Penalty Act of 1996. In 2015, he wrote for the court when it permitted Oklahoma Attorney General Scott Pruitt to order the execution of Scott Eisenberg, prompting a 30-page dissent by Judge Mary Beck Briscoe. After the state's unsuccessful execution of Clayton Lockett, Gorsuch joined Briscoe when the court unanimously allowed Attorney General Pruitt to continue using the same lethal injection protocol. That ruling was upheld 5-4 by the Supreme Court in Glossop v. Gross. Brought to you by WikiVidi Documentaries. Would you like to know more?